you should spell your name and your business or mailing address and your relationship to the property. If you're not the property owner or an attorney representing the property owner, then you must present a power of attorney or an affidavit in order for your testimony to be taken on behalf of the property owner. For new cases, you will be asked for the record if you're aware and understand the violation that is being heard today, and if you understand what is necessary to resolve the violation. The city will present its case first, and then the property owner, alleged violator, will be given an opportunity to testify on their own behalf. You can bring witnesses to testify, you can present any evidence that is relevant and photographs, and also you have the right to cross-examine the city's witnesses. Following the case presentation, I will issue the findings of fact on the case. If I find that a violation exists on the property, then depending upon the case, I will set an abatement or a compliance date for the violation to be resolved. Or for repeat violations, I will impose a daily fine amount. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation and a daily fine amount that I may impose at a future hearing should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement action at this time, I will table or continue this case to another proceeding in the future. If you do not agree with my findings of fact or my ruling, then the property owner may appeal my administrative order on the case to the Circuit Court of Miami-Dade County. An appeal must be filed within 30 days of the date of the execution or the signing of my administrative order to be appealed. In accordance with Florida law, if a person decides to appeal any decision made by a special magistrate with respect to any matter considered at these proceedings, then the person will need to have a verbatim record or a transcript of the proceedings in order to be able to appeal. This record includes the testimony and evidence upon which the appeal is going to be based. The cost of obtaining the transcript shall be the sole responsibility of the appellant, and it is recommended that persons who plan to appeal their case should provide their own court reporter at this proceeding. Pursuant to city codes, if the city of North Miami prevails in prosecuting a case before me, then the city shall be entitled to recover costs, reasonable costs incurred in prosecuting the case, and the current cost assessment amount per the code is $100 per case. Once the city records an order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative fees to record and release the lien. So I have, I guess, completed the preliminary statements. I believe that at this point, we will do the Pledge of Allegiance. Is that correct, Madam Clerk?
Yes, Magistrate.
Okay, so let's do the Pledge of Allegiance, and then after that, you can swear the interpreters and the officers. We have an officer present?
Yes, we do.
Okay, is that you?
Yes, it is.
Tell us who you are.
Officer Carter.
Nice to see you. Good morning. All
Good
right,
morning.
We're ready for the pledge.
Okay. If everyone can place their hands over their heart, we shall begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Moving on to the swearing in of the officers, can you please raise your right hand? Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do.
I do.
Thank you. Now for the translators.
Do we have the translators available?
Yes, this is Hans Martinez, a Spanish interpreter.
And the Creole interpreter? No Creole interpreter. Okay, go ahead, Erica.
Okay. Do you swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skill, and ability? Say I do.
I do.
Thank you.
All right. Madam Clerk, is it your turn?
Yes, sir. Good morning, and thank you everyone for participating in today's special magistrate hearing. I will be reviewing the process by which today's hearing will be conducted. Make sure all your devices is muted at all times unless you are giving testimony on a case. If you are using 2 devices to participate in today's hearing, be sure your audio is only enabled on 1 device. When your case is called, if you are signed into Zoom, you will receive a notification giving you access to the audio and video so that you may give your testimony. If you are physically here at the City Hall and wish to give a testimony, you must sign in at the code clerk and await your text indicating your case is ready to be heard. Upon receiving that message, you should immediately come to the Code Compliance Department office to be provided access to a computer. If you would like to speak on behalf of a case, once the case is called, you should click the raise hand button to be acknowledged. Before giving your testimony on your case, please state your name, property address, and relationship to the property. If you wish to have an interpreter assist during your case, please indicate that when your case is called. Magistrate, that concludes the instructions.
All right. Any additions, amendments, deletions to the agenda?
Yes, we do. So we do have a few cases that were removed from the agenda. So case number 4 was postponed.
Hang on. Okay.
That's Adela Estrella Morgan, case number CEBPR 2022-00771. We also have case number.
By the way, is there a reason why it was postponed? It seems like I had already adjudicated the case and set a daily fine. Is there a
the property owner requested it to be postponed, and the officer gave them more time.
Okay. Hang on just a second. Just so that the officer is aware, I reviewed the file, and there are some pictures that were attached of some landscaping which have nothing to do with the file. So if and when the case comes back before me, make sure that you got the right pictures on there. Yes,
Magistrate.
Okay.
We also have case number 15, Golden Terrace Condo, case number CEWWC 2023-00125.
What are we doing with case 15?
We are postponing that as well. It had some missing documents.
Hang on one second. Okay. Yes, sir. Yes, sir.
As part of our diligencies here in the department, one of the things that we've been doing is we have a pre-hearing agenda meeting with the staff, including our city attorney. So this was the second meeting that we've had in order to make sure the stuff like due process and services are being followed. If there's pictures that are not depicting the correct item, those stuff there's a couple extra this week. But as we review the agendas, this will definitely get better, sir.
Yeah, I appreciate that. I was confused when I reviewed the file. It was supposed to be a case involving an expired permit of a window, and while there's some pictures of a window, when you open the attachments, the first thing you see are pictures of trees. So I just wondered if that was a mistake or what. But in any event, yeah, you know, it happens occasionally. It's not rare to see that. But let's try to do a bit better. Okay, let's hear the next one.
So we have also case number 16, Golden Terrace Condo Main. That's CEWWC 2023-00126. That goes with case number 15 as well. So we postponed both of those due to some items missing. And the last case we have postponed is case number 19, Jean Max Forville and W. Jocelyn, CEBPR 2023-00806.
Okay. Well, that's not too bad. It's a short agenda, too, so it's makes our day a little shorter. So that's good. All right. So are we ready to start with number 1?
So we will start. We have some people who are registered for the agenda. So we'll go ahead and call into record case number 7, 8, and 9. That's
okay. The same property owner.
Same property owner. That's
okay.
Adri Voitenko. Case number 7, CEBPR 2022-00676. Case number 8, CEBPR 2022-00677. And case number 9, CEBPR 2022-00678.
All right, let's start with number 7. It's 655 Northeast 143rd Street, 2-bathroom remodeling. What is that about?
Yes, Your Honor.
Yes, let me hear from the officer, and please speak loud and clear so I can hear you better.
Yes, can you hear me?
Yes.
Is the property owner present?
Okay, I don't see Adriana here. So Adriana is not here, Magistrate.
All right. Do you think she'll, and I don't know who Adriana is. Is she the managing agent or an owner or what?
Gennaro, is she?
No, she's not a property owner.
Okay, well, if she signs in on Magistrate, we can, oh, here she is. I see her.
Oh, yes, that's the property owner.
All right. Adriana, if you can accept the invitation, please. Andrew Voitenko, if you can please accept the invitation. She was here and then, all right, here we go. Adri, if you can please raise your right hand.
He did.
Okay, do you solemnly swear or affirm the testimony you're about to give to these proceedings shall be the truth and the whole truth and nothing but the truth? So help you God. Please say I do.
I do.
Okay, let's hear number 7.
Yes, good morning. On September 1st of 2022, the case was open to a property address 655 Northeast 143rd Street. This violation was found after workers who let me into the property, and I observed that they were doing 2 bathroom remodelings without a permit. I had an inspection September 12, 2022. There was no compliance, and several extensions have been given. On February 2nd, 2024, the notice to appear was posted. It was mailed on February 5th, 2024. And as of my final inspection on February 21st, there has been no compliance.
You said that an extension had been granted, or at least one?
2 extensions have been granted, Your Honor.
Okay, can you show me the pictures of the bathroom remodeling? Can you put those up? Okay, that's one bathroom, and that's the same one? That's the other bathroom?
Yes, Your Honor.
Okay, and you say the whoever was doing the work let you in?
There was no permit at the moment.
My question is, who let you in?
All the workers. So I went because they had a debris outside. I was following up on a complaint, and then when I observed they weren't doing work, they didn't have no permit, and the workers at the moment that they allow me to go inside and do an inspection.
Okay, were the workers themselves licensed contractors or subcontractors?
Yes.
They were licensed as what?
I don't recall right now, but I asked. I observed that that they were licensed.
Okay. Did you ask him why they didn't pull a permit?
No, Your Honor.
Okay. So, but they let you in and you took some pictures, and did you review the records to determine whether or not permits have been pulled for the 2 bathrooms?
Yes, there was no permit at the moment.
Okay. And to this day, they haven't complied.
Well, they pull a permit, but it hasn't been finalized, so that's they pull a permit, yes, but I mean, there's been for a while, and the permit hasn't been finalized.
That means that they filed the paperwork, but the city has not accepted the application for a permit. They don't have a permit. Right.
So they apply for the permit, but they're still working on, so.
Yeah, but they still don't have a permit.
They still don't have a permit.
Okay, let me hear from you. How do you pronounce your name?
Andre, Your Honor.
Okay, Andre, what happened?
Your Honor, indeed, I wanted to replace the tile and repaint kind of the bathroom because it was old bathroom, and I was never engaged really in construction, so I honestly didn't know that I need permit, and my workers didn't tell me. But I understand and I accept that I have violated the kind of the rules and the code. Now, since then, I hired another company that helped me to comply with the code. Their name is Arquiteco. Those are the people who are building houses, actually. We have filed for a remodeling permit. The permit was approved. We actually have 2 cases, Your Honor.
Yeah, but let's hear about this case first.
Okay, yeah, absolutely. Let's start with this one. So the permit got approved last year, and we scheduled 1 inspection. So it's approved. The permit is approved. The city has approved the permit.
When?
Have we Thank you so much. Yes.
No. When was the permit approved? I thought I heard from the inspector.
I will ask Mr. Murillo to help me here because I think he has records. I can pull it too, but I will need to log into the system. I think it was.
I'm sorry, it haven't been approved yet, so I don't see a final inspection from the building department.
No. But the permit itself for the renovation has been provided. So,
Sir, let me try to clarify something.
yeah,
There's a difference between making an application for a building permit
yes,
and receiving a building permit and then having an inspection to clear up the violation. You're probably at the stage where you applied for a permit, but you don't have an actual permit yet.
for the bathroom renovation, I do have permit issued, and we asked the inspector to stop by 2 weeks ago to pass the inspection. Inspector did stop by. We had 2 inspections. One was the plumbing, and another one was electrical. And the plumber inspector stopped by to pass the inspection, and his request was to provide the evidence that we haven't renovated anything behind the walls, because he wanted to confirm that. And so he requested the letter from a certified engineer to provide that confirmation. And that's what my subcontractor is doing right now. We already find an engineer who can provide it. And 2 days ago, they confirmed that they can work with me, and they will provide this letter basically so that we can schedule another inspection. And the inspector can stop by, and we will give him this letter on the property because that was his request. And the reason we haven't asked the electrical inspection to stop by yet is because the plumbing inspector told us that we would need this letter anyway. So let us provide this letter, and then we do plumbing and electrical at the same day.
All right, let me stop you. Let me stop you there. I don't want to get into a lot of the details. How much time do you need to comply?
Your Honor, that's the first time I'm working with this. I would request 60 days if you permit, because I'm really working on this, and it's just not as fast as I would expect, both from the city and from the way contractors work in Miami. It's something.
Okay, all right. I heard you. Madam Clerk, what are my abatement dates?
Magistrate, your date of abatements are March 20, April 17, and May 22.
All right, Andre, you say you need 60 days. We're in the first week of March. I'm going to give you till May 22nd to get everything done, okay?
Your Honor, I really appreciate it. I just want to tell you that it's my interest to get it fixed, and I really work on it. But it's well, you probably know better than me.
I don't think you have any choice. So I'm gonna give you till May 22nd to fix it.
Yeah.
And then after that, if you don't, then penalties, fines will start accruing. So just mark your calendar. It's going to be May 22nd. May 22nd, okay? It's a little bit more than the time you requested.
Yes.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I have heard from the property owner who is present, and I therefore find in favor of the city, enter an adjudication and set a compliance date of May 22nd, 2024. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. So no fine now, but after May 22nd, the fine will be $250 a day.
I heard you.
Okay, let's hear the next case.
Your Honor, for item number 8, Same property, 655 Northeast 143rd Street on September 1st of 2022. I assert that the property was cited to obtain an after the fact building permit for the concrete that was poured on the back on the property. Out of inspection September 12, 2022, there was no compliance. Also, the notice to appear was posted for February 2nd, 2024. It was mailed on February 5th. And as of my final inspection, February 21st, 2024, there has been no compliance.
All right. Show me the concrete behind the property that you were talking about, which I think is right next to the pool area.
Yes.
All right. So there is no permit for that either. Andre, same thing. This was done by the same contractor, and he didn't pull a permit.
So yes, exactly, Your Honor. Now the story with this permit is slightly different. If bathroom permit was at least approved, then I need to pass the inspection. Here, I'm working with the city to get this permit approved, and I can explain you why, but I need to go in technicalities if you would allow me. I can give you high-level message that we have provided the updated plan for the city to approve it because the comments were around the steel reinforcement and the fact that it should be properly connected to the pool, and the city requested the letter from a certified electrician to confirm that. Now, the reality is that this concrete slab is not connected physically to the pool, so I can't provide this letter. And last month and a half, I was trying to reach the inspector who provided this comment. I can share you like at least 5 emails I sent to the city, and I called the city. I got no reply. So last week, my contractor has decided to anyway provide updated plan, indicating that like there is actually 1 feet gap between the concrete and the pool, so we don't need to provide this letter in a way because they're not connected. Yes, you see, like there is a small piece between the tile of the pool and between the concrete. There is space, so like they're not connected. It's an island in a way, but visually they are connected because they poured like a concrete, but there is no steel reinforcement. We have submitted this, and if city needs, I can break it and show that there is no metal, right? So now we did it a week and a half ago. City has requested since then to provide not the plan with the digital signature and stamp from the architect, but with the wet and physical. And we resubmitted it 2 days ago. And like I'm also in talks with my contractor to facilitate it as soon as possible to comply. Now, one thing about this permit is that you don't see it in your records, but actually this permit got approved, so issued by the city at the end of last year, before the permit with the bathroom was issued even, so earlier. We haven't passed the inspection for the only reason because my contractor wanted to have 2 inspections in 1 day. After the permit was issued, actually the city changed their mind and reopened the permit and asked us to request additional information. I haven't print-screened the system to prove it to you, but this is the story with this one. So they issued the permit, then they decided to change their mind and ask for additional documents, which are very complicated. This concrete, the steel reinforcement thing, it requires X-ray. It is like really complicated.
All right. Okay. I've heard enough.
I'm sorry. I apologize.
There's too much engineering, which is above my pay grade. But I was wondering, and we have another case on the agenda later on regarding the what zoning and building call a 60/40 rule. And this question is not directed to you, Mr. Andre. This is directed to staff. In light of all that concrete in the back of a house and the pool area, do we have a zoning sign off on the permit? No, I'm not asking you, Mr. Wojtenko. I'm asking staff. Is there a zoning a signature that is required here?
Yes, Your Honor.
Have they passed on the application?
For this one?
Yes.
Yeah.
Okay. So there's not too much concrete in the back there. Is it pervious or is it solid concrete, or I mean, how did they conclude that they met the 60/40 rule when about looks to me like at least 80% is concrete and pool?
Well, I don't see any comments here from zoning, but I could tell you that.
Well, you know, I'm going to ask those same questions again when you come before me. I'm also I'm going to also give you until May 22nd to keep everything consistent, because I want to hear it all at one time. And if it turns out that you're still working diligently with the city on May 22nd, then we'll talk about it some more. But as of right now, I am going to find, based on the unrebutted testimony of the city's code compliance officer and the photographs that I've seen, showing that the violation still exists, proper notice has been given, the property owner is present, I find in favor of the city and enter an adjudication, set a compliance date of May 22nd. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Please check with planning and zoning to make sure that you're not violating the 60/40 rule, which I didn't never had a case before, but I know that later on in the agenda we're going to be hearing from a property owner whose driveway is completely impervious, meaning that the water can't drain, so it's going to go to the next property over. So we want to make sure that you have enough green space in the back so that when your property, you know, has a flood, that it doesn't drain to your neighbors. Okay. All right. So that's the second case. Let's hear the third case. You can pass because I have my a video. Let's hear the next case.
Yes, Your Honor.
Murillo.
Yes, same property address, 655 Northeast 143rd Street. This case was opened same day of September 1st of 2022. They were asked to obtain an after-the-fact permit for the new flooring that was done at the pool area. I had an inspection of September 12th of 2022. There was no compliance. The notice to appear was posted on February 2nd. It was mailed on February 5th. And as my final inspection on February 21st of 2024, there has been no compliance.
All right, let me see the pictures of the pool area and the new flooring that you're referring to. All right, the flooring that you're talking about is not inside the pool, it's around the side of the pool, correct?
Yes, Your Honor.
Okay, and that was done without a permit?
Without a permit.
Okay. Andre, same issue?
So same people, same issue. The flooring means the tile. I had basically like gray concrete around the pool. we put the tile on top of this concrete. That's what we did. Same contractors who poured the concrete, etc. The reason we have not compliant is because we filed the one permit for both concrete slab and the tile, it comes in a pack essentially, and so it's tile. It's pretty straightforward.
Yeah, I'm sure it's all going to look nice. It's a pretty house. How long have you owned it?
I bought it in June 2022.
Okay. It looks like it's going to end up being a beautiful home, and you're going to be a good resident and a good neighbor. So as soon as you get these permits resolved, you'll be in the clear. I'm also going to give you till May 22nd on the that pool tile that we just saw. So based on the testimony of the city's code compliance officer, photographs depicting the condition and that the city cited the property owner for. Conditions still exist. Property owner has been given notice. He's appeared and agreed to an adjudication and a compliance date of May 22nd. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. I've kept, sir, just a property owner, just so that you understand, I've kept the fine relatively low. Most of the time, the fines that I set are a bit higher, but I appreciate your candor. I appreciate your efforts to cooperate with the city, which is what we're really trying to do. We're not trying to impose fines on people. This is not about collecting money from people. This is to encourage them to correct the violations. Just want to make that statement overall so that everybody hears it. This is not a money-making thing for the city. This is just to encourage property owners like yourself to work with the city to get these violations resolved. And I appreciate your candor, and hopefully you will not have to come before me again. Thank you for your appearance. I appreciate the fact that you're with us. So now we're going to move on to the next case.
I appreciate your honor. And I want to give, a compliment to Mr. Marillo, because he was also very cooperative. So thank you. Mm-hmm.
We try to work with the property owners.
Yes, thank you so much.
Okay, Magistrate, I'm going to call item number 18 on the agenda. Jacob Pashnik Terrace, Pashnik Irrevocable Trust, case number CEZPU 2023-00194. The officer on this case is Gennaro Murillo, and I'll go ahead and allow the registry.
Yeah, I'd like to have the property owner sworn in.
Sure. Linda, if you can please accept the invitation. We also have Raymond Travolta also, if you can please accept the invitation, as well as Javier Castillo. Linda, please.
Yes.
Your Magistrate, we do have 3 people here on behalf of this case: Linda Batch, Javier Castillo, and Ramon Travado.
All right.
I want to please enable your cameras.
Yeah. The first name you mentioned you said Linda?
Linda Bach.
Linda Bach. Please enable your camera.
Start video.
And Ramiro who?
Yeah.
Ramon Travado, as well as Javier Castillo.
Okay. Okay.
And
Is everybody on?
we're missing one more. We have Linda, we have Ramon, and we need Javier.
I think it's
Oh,
Roman.
Javier is here. Roman.
Roman.
All right. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth? Please, so help you God, please say I do.
I do.
All right. Who is going to testify on behalf of the owner? All three of you?
I can testify for myself. I'm an owner.
All right. Let me start. Let me start. Have they been sworn?
Yes.
All right. Let me start with Javier Castillo. Okay. Who are you representing?
No, I am the tenant of the property.
No, sir, I'm not asking you. I'm asking
I was invited
Javier
by the
Castillo.
city.
No, please don't interrupt. Who do you represent? Hello? Mr. Castillo, we can hear you.
I am the property manager.
You
I
are
am the property manager for the property next door.
You are the property manager for the property next door.
Correct.
Okay. And the property next door is called what?
Keystone Towers Condominium Association.
Okay. Just want to get the party straight. That's,
No problem.
just Keystone what?
Towers Condominium Association.
Okay. All right. Now we'll go to Roman Trovato, and I want you to tell me who you are representing.
No, I am the hello. I am the tenant of the property.
You are the tenant.
Yes.
And who's your landlord?
No, the landlord is no in the country. Now.
What's the owner's name?
Jacob Parsix, Irrevocable Trust. It's a trust.
Okay. Do you have a lease agreement with the owner, or is it an oral, verbal?
No,
tenancy?
yes, I have a lease agreement. It's more easy for me if I have a translator.
All right. So let's use a Spanish-English translation. And please, I want to know, sir, if you have a lease with the trust that is listed as the property owner, Jacob Prashnik Trustees, Prashnik Irrevocable Trust. Okay. Mr. Translator, please ask him if he has a written lease.
¿Usted tiene un contrato de arrendamiento, señor?
Sí.
Yes.
All right. What is the period of that lease that you have with the owner?
¿Cuál es el periodo de ese contrato de arrendamiento que tiene usted con el dueño?
Comenzó el 1 de mayo de 2023 y termina el 30 de abril de 2024.
1 de marzo de 2023
no,
y termina...
Mayo, 1 de mayo.
¿Mayo?
Mayo, 1 de mayo.
March 1st. March 1st.
So
May.
You stated May 1st.
It begins in March 1st and it ends in April of 25.
Termina el 30 de abril del 2024.
April 30th, 2024. That's when it ends.
All right, so it's about a year lease, right?
Un contrato de un año, ¿verdad?
Sí.
Okay, and what does that lease entitle you to do?
Y bueno, el arrendamiento, el contrato de arrendamiento, ¿qué derecho le otorga para usted hacer?
La verdad que no lo sé. Tengo alquilado todo el lugar y subalquilo algunas de las casas que están en el lugar.
Well, I honestly do not know. I have rented the whole place and I also rent places that are inside the property.
Sir, is one of the businesses that is conducted under your lease the operation of kayaks, paddle boards, and other recreational type equipment?
Señor, uno de los negocios que está bajo tu arrendamiento es la operación de kayaks y otros equipos recreacionales, ¿es correcto?
En realidad, no, ese negocio no lo hago yo. Ese negocio está enfrente nuestro, cruzando la calle, la 135. Hay un local donde hacen excursiones de kayaks. Ellos salían de Oleta Park y me pidieron permiso para poder salir desde la propiedad. Entonces, él y su mujer son amigos y le dimos un lugar para que puedan, para que sus clientes salgan de ahí. Ellos tienen un local comercial frente a nosotros.
All right, let's
Igualmente,
stop. Okay, por favor,
por
pare
favor,
ahí para que el intérprete pueda interpretar. Sir,
por-
Mr. Interpreter, he gave a long speech, but essentially, from what I understand, and correct me if I'm wrong, Mr. Interpreter, there is a business across the street that handles paddle boards and kayaks, and he has given permission for that business to go over his property and use that property for the purpose of accessing the water. Is that
Yes, sir.
correct?
That is correct.
Okay. All right. So he's authorized someone else to use his leased premises to access the, what is that, a canal or what?
Entonces,
Mr.
básicamente usted autorizó a alguien más para usar sus premisas para tener acceso a, ¿qué es eso? ¿Un canal? ¿Un lago? ¿Qué es?
es Arch Creek, es el canal que va bordeando toda la calle 135.
Well, it's Arch Creek, the canal that it's, well, right next to 135th.
Okay. Now I want, and I appreciate Ms. Bach keeping silent while everybody else is talking. Ms. Bach, I assume, correct me if I'm wrong, I assume that you're going to be telling me that you are somehow associated with the property either as an owner or as a managing agent. What is your position with respect to this property?
I live across the street from where they are launching their kayaks, and the people are coming almost into my backyard, 120 people a day.
Okay. So you're more of a witness than a participant in this activity, correct?
And an unfriendly witness.
Okay. You mean a hostile witness?
Yeah, there you go.
Okay. And so you live at Keystone Towers?
No, I live across the street in Keystone Point on Arch Creek
Okay.
Drive.
So you live
So
on
I'm
the other side. You live on the other side of the water.
Correct. And when they launch the kayaks, they tell them go across the street and hang on to that property's dock until all the kayaks are launched, and then we'll all move down the canal together. So I'll have 20 kayaks hanging on to my dock 4 times a day.
Okay. Just we'll save that for later. Right now, I just wanted to have you identified for the record.
Okay.
I have reviewed the entire file. And I am going to ask the city to present the testimony in support of their case. I do recall, if my memory serves me right, that this particular property owner was on a prior agenda months ago. I recognized the name because I recognize the name. And I remember months ago that it was pulled from the agenda. I also reviewed the file to determine who is doing this particular activity. And it's another name. I wrote it down somewhere. South Florida Water Adventures. is listed as the actual operator. So what I want the officer on the case to explain to me is the history behind this operation. Why is South Florida Water Adventures, I want to know why they're not cited. And I want to know why Roman Trovato as the tenant is not cited. And the reason I want to spend a little bit of time on this file is because as I see the pictures, and I live on Biscayne Bay, so I see these people probably not far from where they're launching. I live on the other side of the bay, and what I don't understand is I know police went out there and cited some people. Why is this activity still going on? Mr. Castillo, not Castillo, who's the officer on this? Murillo?
Yes, Your Honor.
Give me a whole history of this issue, because I know it's been going on for a long time, and I'm wondering why it was pulled from the agenda the last time it was before me.
Well, yeah, so basically this started because first they were running the business without a certificate of use, which they obtained it, okay? We're talking about South Florida Adventures, right? Then
I noted that South Florida Water Adventurers is the party that is conducting this enterprise, and but they're across the street.
yes,
They're not allowed to launch from somebody else's property, are they?
they should be allowed to conduct business from a commercial zoning, right? So in this case, they obtained the certificate of use, right? But they kept on launching from the residential property.
Okay, so they're across the street where they received their certificate of use. Zoning allows that use from that site, right? Is that what you're telling me?
Well, that's a commercial property, but from them to launch the kayak, it should be from a commercial zoning district. Which,
Okay.
for example, next to it there's a marina, which they can use that to conduct business, but not from a residential.
Okay,
zone.
so when they receive their certificate of use, and that's from zoning, correct?
Yes,
They were allowed to operate from their existing location as a commercial enterprise.
but they don't have a canal to launch their kayaks
Right.
on that side.
They don't have a canal on that side.
Yes.
Okay, so how are they supposed to operate if they don't have a canal?
For example, like as I was saying, next to it there's a marina,
Okay,
which they can use that, right?
Okay.
But not from this property.
I know, but I don't understand how they can get a certificate of use for something that they can't, from where they can't do business. If they don't have the ability to launch their kayaks from their business, how did they get a certificate of use?
Good morning,
Because they're
Special
not-
Magistrate. If I may interject, I do have some background with this property. Good morning, everybody. Jose Perez, the manager for the Neighborhood Service Department. So I do have some extensive history with this property, as well as the case and as well as the business owner. In itself, the business owner was granted a certificate of use and a business tax receipt to operate. However, they had very stringent restrictions that said you cannot operate from the preserve that is abutting that property where he's rented at right now. They gave him stipulations that if he finds a commercial property that he can launch from, he could use that commercial property as long as it's approved and zoned correctly. Within that being said, they were previously launching from the preserve and from the FIU section, which was in essence causing a nuisance in that area. And it was then cited, and the business owner stopped. and then he moved his business to the location that's across the street from this current address. At that point in time, the property owner went into an agreement with the business owner to allow him to use his property to launch the kayaks. However, the issue came about where the property is actually zoned as residential, which is where we have the issue at this hand. So with that being said, they were cited for the commercial use that was ongoing at the residential zoned property. At that point in time, the property owner as well as the business owner was represented by Mr. Frank Woland, who is a former mayor of the city of North Miami.
I know Frank Woland.
And they came into an agreement with the city attorney's office where they would go ahead and apply for the rezoning of the property to allow the use and allow the kayaking launching to happen from this residential property, as long as they adhered to the agreement, which was that they would apply for the rezoning of that residential property. At this point in time and to date, they have not applied for the rezoning of the property. And at this point in time, Mr. Murillo is citing the property owner because that is what they're actively launching the kayaks from. In essence, if the property owner revokes the access to the business, then this would resolve the violation in itself. However, as evident by Mr. Castillo and Ms. Linda, unfortunately, the property owner as well as the business owner continue to launch from the residential property, which is prohibited. If they were to launch from a marina, then it would be allowed per the zoning and allowances with the city. I hope that gives a little bit more clarification.
I think you've clarified most of the issues that I had. Just a couple of questions, Jose, because I know you've been on this for a while. The property, which is apparently next to Keystone Towers Condo Association, based on the pictures that I've seen, this particular property is in a residential zoning, correct?
That is correct, yes.
As is the condo association.
That is correct.
And under the zoning code, if you are zoned residential, you're not allowed to operate this type of business, correct?
That is correct.
All right, so this owner and this tenant have entered into a one-year lease to operate an illegal business, right?
That is correct.
And you cited the owner of the property, which is a trust. You didn't cite the actual tenant in possession that is conducting the activity. And I'm wondering why. I'm wondering why the tenant wasn't cited.
Well, if I'm not mistaken, the tenant is actually named on the violation itself, but we cited the property owner because the property owner is responsible for their folio should they sever the ties with the business and prevent them from further launching or obtaining the rezoning as agreed, then that would cure the violation. But in essence, I'm pretty sure, correct me if I'm wrong, Gennaro, the business was mentioned in the notice, correct?
That the business?
That correct, yes. The business was mentioned in the original notice.
Okay,
No.
so whatever violations are issued will be, whatever findings I make will apply to the tenant?
Correct.
All right, let me ask you this.
landlord.
Okay, let me ask you this, Jose. You consider this to be a life safety issue for the public?
I would carefully say yes and no, and I say that carefully, and I want to tread carefully because there's also the potential hazard in anything we ever do in life, right? With that being said, if one of these paddleboard renters slips and falls and hits their head in a non-secured launching site, that is potentially a life and safety issue. if one of these kayakers get in front of a moving vessel and get ran over, that is potentially a life and safety issue. Now, could they be cautious and try to be observant for these things? I'm sure, but there is potential where they can be life and safety issues.
Yeah, yes, ma'am, I'll call you in a minute. Let me hear from the officer. The reason I ask is because I see a tremendous conflict between boating and kayaks and the boards, the surfboards that are used. I see a tremendous conflict. I can see a boat, a yacht going 10, 20 miles an hour and hitting somebody on a kayak, especially if it's dark. It's very little room to maneuver if you're a boater. So I'm looking at conflicts between permitted activities with boats and yachts and these individuals that are on top of basically a piece of wood.
Yeah, no, I agree, and I believe Mr. Raymond, Director Raymond, wanted to actually give a word or two as it relates to this case as well for your input as well.
Yeah, I saw the pictures. I saw probably as many as a dozen kayakers standing. If you show the picture, that's not it, but there's a couple of them with like 10 people on. There's a better one. Keep going. That's one. See, there's a lot of boat traffic in the area, and there, you can see where a collision is almost inevitable if it hasn't happened yet. I'll hear from the witness in a moment, but do you, Jose, do you consider this violation to be irreparable and irreversible?
At this time, I would say it wouldn't be irreparable or irreversible in the sense where they can obtain the rezoning aspect of the property. So we always give them that option. Hey, you can rezone the property and abide by the regulations, or cease the operations altogether, and that would solve the violation. In this case, we're not citing for the individual launching that happens every single time. We're citing for the operations as a whole, which can have a resolution.
All right. I'd love to hear from zoning about the chances of this property ever being rezoned for this type of practice, particularly adjacent to a large condominium. And I'm going to hear from you now, Ms. Bach. I want to give you an opportunity, Mr. Trovato. I'll call you in a minute, but let me hear from. I assume the city is okay with Linda Bach speaking as a witness.
That is correct. Although Mr. Raymond did want to have a remark he wanted to mention as well.
Okay, let me hear from Mr. Raymond first.
The magistrate.
Yes.
In this case, also there's also the addition of that many people crossing the street. Just that in itself, it's right in the middle of the street. Knowing how patterns are observed, I don't know how they're crossing the street, but crossing the street with a paddleboard to conduct business is probably not a good business plan. In addition, it does add another life safety component to this aspect, which is just not based on the sea. It's actually based on the operation that anytime you have that many individuals with equipment crossing the street, it's something that's relevant and will point towards a life safety issue.
I appreciate that. And the street that we're talking about is 135th Street?
Yes, sir.
Okay. Okay. All right. Thank you very much. Ms. Bach, tell us what's on your mind.
I have 3 safety concerns. Number one, as a physician, I see them launching the kayaks in the middle of lightning and thunderstorms, and children getting onto the kayaks, lifting them in the middle of lightning. So I actually couldn't stand it anymore. And so I went out and I said, do you realize that it's lightning? There's lightning. And he goes, oh, it's okay. It'll be fine. So number one, I find that a big concern as a person who treats people who are injured. Number two, the canal that I live on is a very busy canal because it's one of the only two outlets to the bay. So we get a lot of traffic up and down this canal, especially of big boats that can't go under the little bridge that's also in Keystone. And a lot of people just don't observe the no wake sign, boaters. And so there's a lot of wake going on, which is really not safe. Plus, there's the marina right down the canal from this. So a lot of people come down there to get gas. And plus, there's all the boat launching from the marina. So there's a lot of traffic going right by that area. And then there's a lot of these kayaks are just hanging there waiting, waiting for everyone, to get onto the kayaks, for them to launch all the kayaks. So there's a lot of people just sort of hanging around, with all this boat traffic. And it's just really not safe, especially them launching in the middle of a thunderstorm.
Yeah, I understand your testimony. I know that Roman Trovato has something to say, sir.
Yes.
What do you have to say to the city's allegation that you're conducting through your property with your permission an illegal business? And I'm going to have the translator translate that.
Básicamente, señor Trovato, ¿qué tienes que usted decirle a la ciudad respecto a esta alegación que usted está conduciendo a través de su propiedad un negocio ilegal?
Sí, yo cuando les di el permiso para poder, en realidad el negocio no es mío, no me pertenece a mí el negocio de los kayaks, pero yo sabía que mitad del lote era comercial y mitad residencial, y tenía entendido que como era comercial se podía hacer, por eso se le dio el permiso para hacerlo. Pero igualmente, luego de que el señor Llenaro nos envió esta segunda carta, el 6 de febrero yo les dije que saquen todo y que no se podía hacer más la actividad. O sea que desde el 6 de febrero que esto no se hace más. Yo les dije que no podían hacerlo más.
Well, the thing is that when I gave him permission to be able to operate the business, I had, first of all, that business does not belong to me. I had understood that half of the property that I rent, half of it is commercial and half of it is residential. Therefore, that is the reason why I gave him the permission because it was half of it was commercial. However, once I received a letter from Mr. Gennaro, when I received this second letter, I told him on February 6th, I told him that they cannot continue with their operation, that they cannot continue to operate because it was not good. So basically on the 6th of February, everything has stopped.
Well, I hope so. Mr. Trovato, do you live on the premises?
Bueno, eso espero. Señor Trovato, ¿usted vive ahí en las premisas?
No.
No.
Who lives on the property?
¿Quién vive ahí en la propiedad?
No, 3 familias distintas.
3 different families.
And do you have leases with them?
¿Y tiene usted contratos de arrendamiento con ellos?
Sí, tengo contratos de 1 año por escrito.
Yes, I have leases. I have leasing agreements for 1 year, written down, everything in paper.
Okay. All right. I'm not going to prolong this because to me this is very, very clear. Is there anyone from zoning, Madam City Attorney? What do you think the chances are of this property ever being rezoned to allow this particular use? What do you think the chances are?
Good morning, everyone. We would have to speak with someone from zoning to know exactly what the chances are in terms of them getting the variance and allowing them to continue with their business there. I wouldn't be able to respond without having some type of opinion from zoning.
Okay. Based on my experience and common sense with a large condominium property next to it, and the conflict that exists between boaters and kayakers, I will tell you that it's probably slim and none, the chances of the property being rezoned. But I'm not the city attorney. I'm not a planning expert, just experience. So for the time being, I understand that the operation has ceased. But here's what we're going to do. I am going to impose a fine of $1,000 on the property owner. And to the extent that the city is able to enforce it as to the tenant, I would order that the fine also accrue to the tenant. And I would also order that if it has not stopped, this operation must cease and desist within 24 hours, or if it does not cease and desist within 24 hours, if it continues beyond 24 hours, I will fine the property owner and the operator $1,000 a day for every day of non-compliance. So I'm going to deviate from my standard order, which grants a little bit of time, because I do consider this to be a public safety issue. And I know that they've been engaging in this activity for a while, because I remember seeing this particular file several months ago where this activity was ongoing without a variance or a permit. So, Madam Clerk, have I made my order clear enough, or do you want me to clarify it further?
So from my understanding, you want to place a $1,000 fine on the business owner as well as the tenant. And if they do not stop the process of the business, then there will be within 24 hours, there will be a $1,000 per day.
Yeah, I didn't mean to say the business owner. I meant to say the owner of the property, the trust. Okay. And make sure when you record this that that it's recorded specifically against the trust. Make sure that the trustee gets served and noticed if they haven't gotten served already of the fine. This is an unusual way of owning real estate. I don't see, is there a trustee in this trust? Who is the trustee? I saw Monique Benson as a trustee. Is she a trustee according to your records? Jose, please feel free to weigh in on this.
Disculpe, el dueño de la propiedad falleció y quedó el trust. Igualmente, nosotros...
No, wait, I didn't call upon you, sir. I'm not asking you. I'm asking staff to tell me who the trustee of this trust is and whether or not that person has been served.
For the trustees, we do have Jacob Parsnick Trust. There's a Parsnick Irrevocable and a Monique Benson listed as the owners.
Okay. All right. And so the trust was served by serving who? Monique Benson? How was the trust served?
I'm looking at the records now. One moment. It was served by means of postage at the property, and they were served by means of certified mail to the registered address of 6291 Miller Road in South Miami, Florida, 33155.
Okay. All right. So, Madam Clerk, just so that we're clear, I'm not able, unless the city attorney tells me so, I'm not able to levy a judgment against the business of South Florida Water Adventurers. Although conceivably they're violating their permit. From what Jose told me, they were not permitted to launch from certain areas. And Jose, is this one of the areas where they're not allowed to launch?
They're not allowed to launch from public property and the preserves. That was the stipulation that was granted when they were obtained the licensure. In this aspect, it is private property, so that is not the restriction that was set on their business tax receipt and certificate of use.
Okay, I thought I read that one of the prohibitions was that they could not launch from a residential area.
That may have well been included as a stipulation, but I know originally the main trajectory was you can't use public property because that was the original cause of what they were doing. All
right, I just don't want to keep playing whack-a-mole. If they'll stop here, and then they'll resume their operations a few blocks away. So I think the city needs to monitor this company, and if they want to launch out of Hollover Beach, they're welcome to it. But if they launch from an area that is not zoned appropriately, the city should follow up. But with respect to my order, Madam Clerk, just to return to it, my order applies to the Prashnik Irrevocable Trust, Jacob Prashnik, trustee, and Monique Benson, trustee, whoever they are, dead or alive. A trust doesn't die. Okay. A trust is dissolved, but if the property is in the name of a trust, that's who the owner is. And so that's one violator. The second violator is the tenant who's authorizing this use, which is not permitted in a residential area. He's a joint violator, and he's being also similarly fined, as I said before. And if it continues beyond 24 hours, it's $1,000 a day. I want to hear now from the tenant, Roman Trovato, and through the interpreter. Señor Trovato.
Sí, entiendo más o menos entiendo. Por lo que entendí es que si se continúa con la actividad de los kayaks, se va a poner una multa, ¿es correcto?
Well, I think I understood a bit. What I had understood is that if this was to continue, that I'm going to be fined. Is that what I understood?
Yes, but he's also being fined $1,000 for what has happened before today, for the activity itself, for conducting that activity illegally. For that past violations, it's $1,000. $1,000 fine, and then after, if it continues, it'll increase to $1,000 a day for every day that there's activity going on there that is prohibited by the code.
Así es, mas sin embargo también usted va a ser multado por $1,000 por lo que ya pasó, por la actividad que ya pasó anteriormente, por la actividad que usted permitió que pasara ilegalmente, por todas esas violaciones anteriores. Si esto llegara a continuar con las actividades, básicamente usted será multado $1,000 el día, cada día, por la actividad prohibida y la violación de códigos.
Ok, yo por eso dos cosas quiero aclarar. Una es que desde el 6 de febrero no se hace más la actividad. Le dije que no podían hacerla más y se retiró absolutamente todo de la propiedad, los kayaks y absolutamente todo, y que yo termino mi contrato de alquiler el 30 de abril y no lo voy a renovar, así que me imagino que seré responsable hasta el 30 de abril, que es mientras voy a ser yo tenant. Está bien, pero desde el 1 de mayo yo ya no voy a tener más relación con la propiedad.
Well, two things that I wanted to clarify. stopped all the activities since February the 6th. I told him that he could not be able to continue with his activities. He removed everything from the property. Everything has been stopped. And another thing that I want to clarify, on the 30th of April, I would, my lease is done and I'm not gonna renew it. So I'm not gonna be a tenant starting May 1st. I just want to clarify that I'm not gonna be, responsible for being the tenant starting May 1st.
I understand what he said earlier about the length of his tenancy, but as the tenant, he's responsible for all activities that take place, whether he knows about them or not, until April 30th. And if he permits, even if he's not aware, he may have to do some monitoring, but if he becomes aware that the activity is still ongoing, then he'll be fined again. So he has to make sure that as long as he's the tenant, he's not going to permit any operation that is illegal, and he may have to fence the property. He may have to have a conversation with the commercial entity across the street, South Florida Water Adventures, and make sure that they understand also that they're not allowed to use this property for any purpose.
Ok.
¿Entendió, señor, o necesita que se lo repita?
Por las dudas, si me lo repetís. Creo que entendí, pero por las dudas.
Básicamente él entiende el tiempo y la duración de su contrato, más sin embargo de aquí hasta abril 30, con su permiso o sin su permiso, usted tiene que asegurarse de que estas actividades no vuelvan a suceder porque vas a ser multado de nuevo. Tienes que asegurarte, ya sea hablar, poner una barda, hablar con la persona encargada de el negocio, que viene siendo South Florida Aventuras de Agua, y como le digo, tiene que usted asegurarse de que nada de eso pase mientras está bajo contrato.
Ok, perfecto.
Magistrate.
Yes.
So if the violation continues after the 24 hours, are we just doing the $1,000 per day for the tenant or the tenant and the trust?
Both.
Both. Got it. Thank you.
Until April the 30th, when the tenant vacates the property, then it'll be against the property owner also. I also want the city attorney to consider potential enforcement against South Florida Water Adventures. There's a saying that, you can't do indirectly what you can do directly, what you can't do directly. And if they come up for renewal, their certificate of use, business tax receipt, they have to identify, and this is just my recommendation, I can't order this, but that particular business entity has to identify a location from which they will be, a legal location from which they will launch these activities. I think that should be a requirement of their certificate of use. Ms. Back, any final remarks?
No, I appreciate your consideration on this matter.
Okay. Anyway, it's something that I think needs to be addressed very quickly to, if for no other reason, respect the rights of the other residents in the residential area, including the condo association, Keystone Towers. I also believe, and I have seen very bad accidents happen since, again, I'm close by. I can almost see Keystone Point from where I live, and I see these reckless people, mostly on jet skis, not so much in kayaks, but I see kayaks being operated at night sometimes. There's no lighting, there's no reflection, and it's very, very easy for a boater to run into somebody. And then they end up being treated by Linda Bach, and that's not a good thing. Okay, next case.
Thank you.
Okay, Magistrate, the next case we're going to call is item number 3, Ada Hernandez, CEBPR 2023-00821. The officer on this case is Gennaro Murillo. We also have Lizen Maldonado, representing the case. Lizen Maldonado, please accept the invitation.
All right, is Ms. Maldonado present?
She is present. Please enable your audio and video. All right, Mr. Maldonado, if you can please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
Can't hear you.
You got a translator?
Translator?
Please.
Go ahead.
Okay, buenos días.
¿Qué tal? Buen día.
Ask him to speak up.
¿Puede hablar un poco más fuerte, por favor?
Sí, mira, lo único que estoy pidiendo a este caso, a ver si nos pueden dar un poco más de tiempo, porque ya tenemos un número.
I don't want him to tell me anything about the case right now. All I want him to do is to identify himself.
Señor, no quiero que me diga nada que hacer sobre el caso en estos momentos. Lo único que quiero es que te identifiques.
Nelson Maldonado, solo estoy representando a la señora Ada Hernández.
Nelson Maldonado, I'm representing Miss Ada Hernandez.
Are you a lawyer?
¿Usted es un abogado?
No, yo soy un perrón que está haciendo todo el papeleo.
¿Es un qué, perdón, señor? No lo escucho muy bien.
Perrón, que está haciendo el papeleo. Perrón.
I am the runner, the person who's doing all the paperwork.
I'm not going to take testimony from a runner. Are you a plans expediter? Is that what you do?
No voy a tomar el testimonio de un corredor o de un runner. ¿Usted es una persona que expedía los testimonios o los planifica?
No, yo nada más hago lo que es el papeleo de poner todas las cosas allí y sacar los permisos.
No, what I do is work with all the documentation and basically I get all the permits.
All right, I'm not going to listen to his testimony. That's not what the law provides for. He's neither an agent, property owner, or attorney. So I'm going to completely disregard his testimony and just listen to the city side.
Entonces, básicamente no voy a escuchar su testimonio. Para eso no es la ley. Apenas si fuera usted un agente, un dueño de propiedad o un abogado, en estos momentos vamos a escuchar lo que menciona la ciudad.
Yeah, only Ms. Hernandez is allowed to testify, and any lawyer or agent that she authorizes. Do you have a power of attorney? Do you have any written authority to be representing Ada Hernandez?
Solamente la señora Hernández o algún abogado o algún agente que ella autorizó. ¿Usted tiene algún documento que le otorgue usted el derecho para representar a la señora Ada Hernández?
Ayer yo hablé con el señor Murillo y por la mañana él me dijo que la señora me autorizara. Ella hizo un papel poniendo mi nombre y autorizándome y firmando.
Well, I actually spoke to Mr. Murillo. He stated that Ms. Ada needed to do a documentation where she needed to write down that I was authorized, and she actually signed it.
Mr. Murillo, is there a document authorizing this gentleman to speak on behalf of the property owner?
I told him that document that he sent, it was not acceptable. That he needed to a power of attorney or something from Ms. Ada, which he didn't provide.
All right. Let me hear from you then, Officer Murillo. What is this? Is work on a pool that was done without permits? Tell me what the status of it is.
Yes, Your Honor. So this case was opened on May 6th of 2023 for the property address 2340 Bayview Lane. As you observed, they were doing a pool work without a permit. I spoke with Mr. Maldonado on March 23 of 2023, and he said that he was going to be working on obtaining the permits. But as of my final inspection on September 21st, 2024, there has been no permit on file.
Yeah, I saw that in the file that on March 23, that was almost a year ago, Mr. Maldonado told you that he was, quote, working to obtain permits, and here we are a year later. So I think it's time to move this case along based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violations still exist. Proper notice has been given. I find in favor of the city. Enter an adjudication and set a compliance date of April 17th. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. All right, we're done. Next case.
All right, Magistrate, the next case we're going to call is item number 6. Anais Rios, case number CEBPR 2023-00910. The officer on this case is Gennaro Murillo, and I'll allow the attendee in.
All right, this is the property owner, Anais Rios, present.
She is present. Anais, please accept the invitation and enable your audio and video.
Hello. You have to press this. There.
All Hello? Right. I see a lady and a gentleman. Anais Rios, identify yourself.
Hi, yes, this is Anais Rios, the property owner, and my husband, Daniel Rios, also the property owner.
Okay.
Magistrate, let me swear them in.
Yes.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say, I do.
I do.
All right. Let me ask either one of you whether you understand the nature of the violations that the city is charging you with. Just yes or no. Do you understand?
Yes, we have an idea what's going on.
Okay. Okay. So do I. I've reviewed the file. I know what the case is about. So I want to get down to the issue. Okay. Do you understand the 60-40 rule?
Well, after the violation it's trying to be issued, we have been working back and forth with the city, and more or less, yes, we do have an idea of what's going on.
Okay. You understand, ma'am? You understand what the issue is, right?
Yeah. Yes.
You have a beautiful home, okay? Beautiful landscaping. The artificial turf is in mode these days. A lot of people use it because it doesn't require any maintenance. The concrete blocks, everything looks great, except that the code has a 60-40 requirement to permit water to drain instead of moving to your next door neighbor's house. That's really all, considered by zoning and planning as a component of any home in the city. There has to be drainage, and what you have there is non-pervious, which means that water can't penetrate it. So that's how I see the case. I want to let the inspector correct me if I'm wrong, and if he wants to add anything, talk to me about how do we achieve compliance. I'm sure that the city and the property owner can reach some type of an agreement as to how long it's going to take to correct the violation. I also understand that from the file that you've gotten a permit, the permit has been revoked, the permit has been reinstated and revoked, but we still have the issue of the 60-40 rule. So,
if we may, Your Honor.
If we may, if we may talk, can we talk?
yeah, I want to since we've spoken between ourselves, and you will have all the time necessary, but I want to hear from the inspector first.
Sure.
Sure.
You want me to read the case for you, or
Whatever you need to do, I'm listening.
well, Your Honor, you already reviewed the case. It was open on September 27, 2023. As you know, there's been alterations in on the driveway and needs to be reduced to only have a 60%. I know they're trying to work with the city because extension has been granted per the building department, but so my final inspection there has been no compliance. So the building official is here as well. So I don't know if you.
Oh, I'm glad. I want to hear from the building official. Is the building official present? I want to hear about this 60-40% rule, and also why the permit was issued and revoked and issued and revoked. Doesn't seem fair that once a permit is issued and the file closed, that the city goes back and reopens it. I know it happens, and I know people make mistakes, but I want to hear from the building official.
Hello, I'm present.
All right. So we want to see you and want to hear from you.
Hi there. So this permit was issued, and the permit was closed before I was the building official. It was the prior building official. I know
Are you the new building official?
Yes.
Okay. How long you been with the city?
This would be my third week.
Okay. All right. We appreciate your participation. A lot of building issues come up during these hearings, and so I'm going to call on you periodically from time to time. And so I'm glad you're with us. Tell me the history of this property and why the permit kept getting issued and revoked and issued and revoked, and now we're in La La Land.
So because of the error on the zoning side of it, even though it was given a final approval to close the permit, that final approval was revoked so that compliance could be met in terms of the zoning requirements.
Okay, from what I read, there was an original permit issued, which provided for a new driveway. And is it my understanding, am I correct in assuming that the property owner exceeded the amount of work that was permitted under the original permit?
From my understanding, yes. Remember, the building department enforces Florida building code, not zoning regulations.
Okay.
So from a building standpoint, the construction of it was okay. Now the zoning requirements were not met, and we issued the permit.
But I would expect that before the building official issues, or the building department issues a permit, that you get a sign off from zoning before you do that. Did you not have a sign off from zoning when you issued the final?
There was a sign off from zoning, yes.
Okay, so then the mistake is with zoning.
Correct.
Okay. Anybody from zoning to discuss it and explain how that mistake was made? Okay.
No.
Go ahead.
I don't want to put all the blame on zoning as well. The building department shouldn't have closed the permit if there was an outstanding inspection with zoning.
Yeah, but it's not within the purview of the building official who interprets the building code to determine whether there's a violation of the zoning code, is it?
Correct. We enforce.
All right, so getting down to the actual where we are now. I understand the concerns of the property owner. I don't have to spend a lot of time hearing from them. I would be concerned. I would be unhappy if after getting an approval, the city came back weeks, months later and said, hey, not good, we're going to revoke the permit. City has the right to do that. And, you know, the city attorney may want to weigh in on that. And the property owner may have other avenues to seek relief, but I'm only here to consider code violations. So let me hear from the property owner and ask you, what, if anything, are you doing to comply with the zoning requirement that there be a 60-40 ratio between pervious grounds and impervious grounds?
Okay, Your Honor. Well, since we got the approval by the city of doing this driveway, and we did everything that is in the plans. After we passed the final inspection, after we passed all the inspections, some inspector came and said that it was not by code. So we explained to them that we did everything that was in the plans, that was approved. So after that, we got the letter from Mr. Morillo saying that we have to apply to the 60-40% rule. After that, I just started going back and forth to the city to see what was going on. Because to be honest, I don't know about construction.
It should have been addressed before.
So that's why we going back and forth saying that, because we have all the receipt that we spend more than $40,000 on this driveway. So, I mean,
and paid all the permit fees, got everything. We did it the right way.
We don't do nothing on this house without permit. You get me? Because I know how it is. But since we follow all the rules, how we're getting
penalized now, yeah.
Penalized now.
And now we have to invest more money to try to bring something to code that should have never been approved if that was the case.
Well, the problem, I understand perfectly your situation. It's not the first time that I've seen a building department or a zoning department or a planning department make an error. Happens a lot, actually, and especially in bigger cities. They don't have, sometimes they miss things. They're humans. This happens to be one of those cases that maybe they assumed that grass that you have there in your driveway was real grass. And maybe they thought that complied with the 60-40 rule. It turns out that it's artificial grass, and technically you don't comply. So the only thing I can do, and is enforce the rule. And in the city of North Miami, you have this rule that even though the city made a mistake, you still have to comply with it. Is the city attorney online?
Yes, Special Magistrate.
Okay, do you have any thoughts on whether or not there is some kind of estoppel that the city is stopped from enforcing this particular provision of the code because the city has already approved the permit, and that there has been detrimental reliance by the property owner in spending $40,000 to do this driveway? What is your thought on equitable estoppel?
I would need to have the building inspector on to understand exactly why and how it was approved for them to continue with something that pretty much everyone knows that there's that rule. I don't believe, at least not in my experience, that there's an estoppel for any errors, but that is something that we can discuss with the building official and see how we can move forward.
All right. Mr. Building Official, before I go further, what are your thoughts? How do you propose that the property owner cure the violation, mindful that they've already spent $60,000? What or $40,000? What is it that you would like to see? You want them to shrink the driveway? Do you want them to put real grass? What is it that they have to do in order to comply with the 60/40 rule?
In order to comply with the 60/40 rule, they'd have to provide the green area that's required by zoning. Whether that's the artificial grass and replace it with actual grass, meet the setbacks on the sides with real grass. Again, that's a zoning issue. So, I mean, I'm not too clear on the zoning ordinances. I enforce the Florida Building Code.
Okay. And since we have nobody from zoning attend these hearings, I think I'm going to table this until there's an opportunity for the property.
Your Honor.
Yes, sir.
I'm trying to find an email, but as I must understand, Vicky Santos from the building department, she said March, while they were still doing the work, and told them that to make the corrections, and they had the opportunity to make the corrections at the time when they were still doing the work.
Okay, Mr. Rios.
No, we did not, Your Honor. When this Mr. Mark came to the side of here to the property, every single material was here on the side. They were installing the pavers. All was here. All the money was spent already. So everything was here on the property.
Okay. But was it before you installed and put in place the pavers?
We were installing the pavers that day. So another thing that I would like to say is that they told us that Mr. Mark, I believe the name of the guy, that some neighbors complained with our driveway. I personally called the city code enforcement to verify that, and there was no complaints about our.
That's not relevant. I don't care if people complain or they don't complain.
Okay.
Or who they complain. I don't care if the mayor complains. It doesn't matter to me. Okay. What matters to me is that there be compliance with the code.
Of course.
Okay, that's all that matters.
And that's what we want. And that's what we want.
And right now, you're not in compliance. So you're going to need to reduce the concrete, provide more pervious areas so that the water will drain and not affect your neighbors on each side. Okay. Because that's what, what happens with flooding is if the water doesn't percolate down, it's going to go to your neighbor. And your neighbor has as much rights as you, and you don't have the ability to flood your neighbor's property by making your entire property concrete. And then all the water has no place to go except your neighbor's property. And that's what we're trying to prevent. So here's what I'm going to do. I'm going to give you some time to work with planning and zoning and the building official, maybe even the city attorney. But I'm going to give you time. You must come back with a plan that is acceptable to zoning, and in the most efficient, cost affordable way. And, if the city attorney feels like, maybe the city should consider a variance or consider some other way of dealing with the issue based on the fact that they originally gave you a permit and then they revoked the permit and so on and so forth, you all talk it out. But in the meantime, I am going to find you in violation of the code in that your driveway is not compliant with the 60-40% rule. Notice has been given. The owners are here and testifying on their behalf, but I will enter an adjudication and set an abatement date, a compliance date of May 22nd. You have until May 22nd to comply with the rule or settle in some way with the city, enter into some kind of a settlement with the city or the city attorney or whoever. But if there is no compliance, if there's no formal settlement agreement or compliance, there will be a daily fine of $250 until the violation is abated. So between now and May 22nd, you need to find some solution, even if it ends up costing you a little bit of money, because we cannot allow your property to drain to your neighbors on each side. And I cannot, in good conscience, allow you to be in violation of the code. Whether you have a legal case against the city, I can't comment on that. That's, you should retain an attorney if you feel that the city did something wrong. Speak to an attorney, protect your rights, and if you feel you've been wrong, you can take the city to court. But I am not allowed to deviate from the strict provisions of the code. You all understand that?
Yes.
Okay, I hope you can all work it out. You have a beautiful home. I love the way, that you've set out the front driveway. I think it's great, but there's just a little bit of a problem that we need to resolve. And I wish you all well, and I'm ready for the next case.
Thank you.
Thank you, Mr. Arnold. Thank you all.
You're welcome.
Sorry about that. All right, Magistrate, we're going to call item number 24 and item number 25. N&W 1051 Inc., case number CEFOB 2023-00494, case number item number 25. N&W 1051 Inc., case number CEZCU 2023-00823.
All right, before we hear these cases, I just want to let you know in advance that as soon as we're done with 24 and 25, we're going to take a 10-minute break. We'll take a 10-minute bathroom break or whatever you want to do, any emergency calls or anything you need to address. We're going to take a 10-minute break as soon as we finish with 24 and 25.
Okay.
All right, let's hear 24.
So we do have attendee Avil June Jens. They are the leasee of the property.
They are the what of the property?
The leasee, the person leasing. So
Okay,
Avil, can you
spell the name?
Avell. Last name is JEUNE-GENS.
All right, I see that now on the screen. Okay, and he's the tenant?
Yes.
Okay.
Avil, can you please enable your audio and video?
Hang on 1 second, please. I'll be right back. I'll be back in 30 seconds. I need to address an emergency, so just give me 1 minute.
Sure.
All right, let's resume. Where were we?
Okay, and we have Shanna Sanders on both of these cases.
All right, the first case has to do with a lack of a business tax receipt, and the other case, case 25, is a certificate of use. I'm sure that there's some relationship between the two, so we can hear the two of them together.
Okay, let me swear in the attendee. Please raise your right hand.
Sorry, so I'm his granddaughter. Ava is the tenant. So I've been assisting him since he has been ill. So I can give some information as to the process and where he is in the process of the documents as well.
Okay, and you're Abel, is that how you pronounce your name?
Grandpa, he said how you pronounce your name.
Abel.
Okay, and the granddaughter's name is?
Lanisha.
Spell that?
Lanisha. You need my last name as well?
Yes.
Yes, please.
JEAN-PIERRE.
Okay. Is that Lanisha?
Yes.
Okay. All right, I got you. So your grandfather is the owner of the business?
The tenant.
He's the tenant, okay?
Yes.
And this is, the name of the business is what?
Elohim Missionary Baptist Church.
Okay. And I assume from the name that it's carrying out its business as a church.
Correct, church, yes. Church service.
About how many members?
How many members? It's like 20, 25 sometimes.
All right. And it's located at 1049 Northwest 119th Street, correct?
Yes, sir.
All right. Do you understand what the violation?
They weren't sworn in, Magistrate.
Oh, okay. All right. Let's swear them in.
Okay. Can you please both raise your right hand? All right. Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
All right. You can put your hand down. Do you understand the nature of the violations that the city is charging you with?
For the most part, yes. So my grandfather received notification that he had to complete the certificate of use. He had been going down to City Hall to kind of get information as to what he needed to do and what paperwork needed to get done. So when he received it, I assisted him with filling out the paperwork, and then we submitted the documents as a result. So when we logged back in, because he has been having some medical issues, it expressed that 2 of the documents were disapproved. So we redid it because he needed a covenant document. And then he needed a letter that was signed by himself and the owner of the property stating the square footage. So he got those and he uploaded them. They needed 24 hours to review them. And when I looked at the document review this morning, it stated that the square footage letter was disapproved again. So I sent the email to follow up on in regards to what was the reason for the disapproval, because that was specifically what was notated needed to be done.
Okay. How long has your grandfather been operating this church?
I'm sorry. Give me 1 second because the dog's barking. I'm sorry.
You want me to repeat it?
Yes, please. You said about how long?
How long has your grandfather been operating this church?
How long you been at that location, Grandpa?
Oh, since 20, but let me see. 20.
Like a year?
Yeah, but
like how long? 6 months, a year?
Yeah, I think 2 years, 2-3 years, something.
Okay. It's not 2 years?
Yeah, 2.
So about a year and some months, because he's not certain.
Okay, you understand that in order to do any business in North Miami, you need two things. You need a certificate of use, which you said you're working on, and you need also a business tax receipt, which is just paying a tax to operate. But you can't get one without the other. They have to come together. You understand that? Okay. Now let me hear from the officer, and then I'll make a decision on what to do.
Okay.
Shannon Sanders.
Can I add one more thing? I'm sorry.
Yeah, real quick.
Prior to receiving the information, he didn't have knowledge of that. So he just had the LLC, I believe, or the incorporation where the church was registered. So I don't think he had knowledge of that prior to the notification from the city.
Okay, what was there before he moved in?
You know what that from when we was doing the certificate of use paperwork, it said a hair salon or something in that range.
All right, so it's a relatively new church that opened there.
Yes.
Okay, well, you need these two items in order to operate. Let me hear from the inspector.
Okay.
Janice Sanders, Neighborhood Service Inspector for the City of North Miami. Both of these cases were originally opened on June 14th of 2023. As you already asked, what business was there before. I originally went to the property to do an inspection. We were doing inspections on businesses that were not in compliance or that needed to renew their business tax receipt. At that time, it was a hair salon. I believe the name was Silver Streak or Blue Streak. I think it was Silver Streak Hair Salon. At the time when I inspected, it was the gentleman and his wife at the property. He brought to my attention he had just moved there. So to answer, I think your first initial question when you're asking the time frame, he stated he had just been there for about a month or two before I visited the property. So if I inspected it on June, I would say he was there roughly April or May of last year. So I would even say short of a year that he's been there from our initial conversation. At that time, I brought to his attention that he needed to obtain the licensure and the certificate of use. Both him and someone who identified themselves as his wife said that they would visit the city to do so. They did within a week or two visit the city as requested. They have been going back and forth with trying to get things approved. It has been taking, quite some time. As the granddaughter has stated, it has been denied for different reasons. From what I recall and from what our conversation was, I believe it's in Durham at this present time. As she just stated, it was denied again yesterday or either this morning. But, they have been trying to, get the certificates. However, again, it's been denied for different reasons through Durham. So the city is kind of at a standstill with issuing it until Durham approve whatever it is that they're asking for. We did have a conversation with the business owner as well as his daughter. She did say that she would ask for an extension. I am okay with granting an extension because, again, they have been diligently working. She, to get that, she has stated that the grandfather has been ill. But I am okay with giving an extension if you would allow that.
I'm going to table it. How's that?
That's fine for me.
I'll hear it. I don't want to adjudicate anything on this yet. I want to table it until my next meeting, and we'll see where we are then. I think that based on the circumstances that they just recently moved in there, the grandfather is not well. They've tried the paperwork. I don't know why it was denied. If it's Durham, I know Durham takes a long time. It is a church. There are 25 members. I don't want to, taint their reputation by entering any kind of adjudication. If all it is doing some paperwork, I would encourage both the grandfather and the granddaughter and perhaps others to work with the city as quickly as possible so that by the time that I hear it, if I'm going to hear it at the next meeting, that they have what they need in order to operate, which is a certificate of use and a business tax receipt. They may need some Durham approval, but if the prior property, the prior tenant was a was a beauty salon, I think that Durham will be delighted to have a church in lieu of a beauty salon. Only because we're not talking about chemicals and other items that go into the sewer system. So anyway, I am going to table this until the next meeting.
Magistrate, your next hearing is May 1st and
Okay.
July 3rd.
Let's do May 1st.
Okay.
And at this point, as I announced a little earlier, we're going to take a 10-minute break. And let's see what time it is.
They also have item number 25 also. Is that your ruling?
Yeah, my ruling is as to both the business tax receipt and the certificate of use. We're going to table those. And I'll see you all back in about 10 minutes. Okay?
Okay.
Recording stopped.
Okay, here we go.
Recording in
Everybody ready?
progress.
All right, let's move on to the next case.
Okay, Magistrate. At this time, we're going to call in case number 22 and 23 on the agenda. It's for Mia Properties, Inc. Case number CEFOB 2023-00475. Case number 23 is for Mia Properties, Inc. as well. Case number CEZCU 2023-00799. The officer for this case is Brentley Daniels. Now go ahead and request the attendee join.
All right, the attendee on behalf of Mia Properties.
Christopher Collins. That would be Christopher Collins. Christopher, if you can please enable your audio and video. All right, Christopher, I'm gonna promote you. So if you can please accept, then enable your audio and video. All right. Christopher, we need you to enable your audio and video, please.
Why don't you go ahead and click on the
The little
believe-
microphone button and the
There we
video
go.
button. Yeah.
Can you hear me now?
Okay,
Yes, we
Christopher
can.
Collins, let's swear him in.
All right, Christopher, if you can please raise your right hand.
I'm not Christopher. I work for Christopher.
Are you an attorney or
It is LLC.
What is your
No,
name,
I
sir?
just work for Chris. Ahmad Al-Jabur.
What is your name?
Ahmad, A-H-M-A-D.
And your last name? Can you hear-
Al-Jabur, A-L-J. I'm sorry?
Yeah, spell your last name.
A-L-J, B as in boy, O-U-R.
How do you pronounce that? Al-Jabur?
Yes.
All right, and who are you here on behalf of?
Christopher Collins is the owner of Urban Design LLC. I work for Urban Design LLC.
What do you do? What do you do
engineer.
what do you do for Urban Design LLC?
What do I do for Urban Design LLC? I'm a civil engineer.
You're an engineer? Sir, you're frozen.
Right.
You're an engineer?
I'm sorry. Yes, I am.
And why is Christopher Collins not present?
In another meeting, that's what I understood.
All right. Do you have a power of attorney, or do you have anything to show that you have the authority to represent Urban Design LLC as an agent or employee?
I don't have any power of attorney. I work for Urban Design, that's all.
But are you representing the entity, or are you just here because Mr. Collins is not available?
Yeah, Mr. Collins asked me to represent him for this call.
Okay, has he been sworn?
Yes. No, actually, no, he has not.
Okay.
All right, if you can please raise your right hand for me, Christopher. Do you solemnly swear or affirm that the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Okay, the first thing I want to clarify is that the citation is against Mia Properties, Inc., not against Urban Design. So, Mr. Code Officer, Inspector Daniel, where's the owner?
Your Honor, that I'm not aware of. The citation was issued